One Honorable Justice Karthik is having some problem. So another bench. Thank you, madam. Yes. Yeah. Yes, Mister. You are for the petitioner.
Yes, Your Lordship, I'm for the petitioner. I have received the affidavits.
You have seen the affidavits filed on behalf of the respondent number 2 and 4.
Yes, Your Lordship, I have received two affidavits from Deputy Commissioner and Deputy US.
Superintendent of Police.
Yes,
Yes. So now what remains?
it's not audible, Your Lordships.
What remains then?
Your Lordship, I have meticulously gone through both the affidavits.
Yeah.
Basically, what the state respondents have endeavored to make in these affidavits, that they have made complete due diligence on their part to ensure that the bandh call was dismantled from its root. However, astonishingly, to the absolute contrary, we are proving our case when we look at the annexures attached.
What is the material which you have based on record?
Your Lordship, all the annexures.
Yeah, read which annexure you are pointing out.
The annexure begins from page number 42 onwards, Your Lordship.
42.
Yes, Your Lordship. In the 42 onwards, when we see.
Just a minute. Just a minute. Wait for a minute. Yes.
Yes, Your Lordship. When we look at the annexures, and unfortunately, we won't be able to play the video which is attached as one of the annexure in the petition. It shows that bandh call indeed took place. Second point is that the state actors were mere spectator. They have impliedly abetted the bandh call. So, my humble submission, I fearfully admit that certain paras which abode in the affidavits are in fact perjury, Your Lordship. Some paragraphs in the affidavit says that bandh call was mere declaration. It was never given effect to.
So how many roads, all the roads of the districts have been
Yes, Your Lordship. Even if some citizens dared to bring the vehicle on the street, absolute violence was made, vandalized, their keys
how
were
many
taken back.
persons were injured in that any violence?
Your Lordship, unfortunately, by the fear of the high-handed non-state actors, no one have came up to file any single report.
Then is the material that
Yes.
they to violence, and how many persons were injured, how many vehicles were damaged, what were the damage?
Yes, Your Lordship. In page number 45 of the petition annexure, Your Lordship,
Yes.
there is one vehicle stopped right outside the gate of the police station.
We are not denying that. Yes, if they organize a bandh and if they resorted to some bandh of the roads and everything, yes, it is not, but it is for the state to take care. But ultimately, what happened?
What happened was that the complete business was shut down of the common citizens.
Fine.
And
They forcefully this pressurized the shopkeepers to shop there.
close.
Yes.
Yeah, basically,
that?
normal, ordinary life of in the day course was put to an end. No one wanted to, if anyone wanted to go to schools, offices, everything were shut down.
Yes.
Basically, legally, if I go to say, Your Lordship, the basic exercise of our fundamental rights were curtailed.
Only the 8% have filed any FIR complaint with the police that they were harassed or they were.
No,
they
we
suffered on
truthfully
account of
admit that no one have dared to come up so far, Your Lordship.
Then, sir, only if, yes, it is condemnable. The police should have taken action against them. But it seems that the bandobast was there and the police was taking care of it. But if some incident was there, we can direct them. In future, they'll take care of that.
Yes, Your Lordship, what pains our heart when we reach to this court is that we believe that the state actors had complete opportunity to avoid it
How?
by completely dismantling the one when it was being enforced that day.
Dismantling, you know, if the mob is there, every time the force can't be used.
Definitely, Your Lordship,
That will
indeed.
be- So prior to that, on the precedent day, they hold a meeting with them. They try to convince them. But if they have not tried, then they have taken care of that.
Your
They
Lordship,
have posted many persons of the security personals and the magistrate and all were there. Then,
even to that effect, Your Lordship, I have some humble submission if Your Lordship may allow.
sure.
Your Lordship, the annexures which is attached in the affidavit which shows that the bun call was declared to be illegal, the basic due diligence which they claim to have been done, Your Lordship, this paper was never brought on public domain before. Even the bun callers have specifically stated on public domain.
This is public domain. What do you mean by public domain?
Your Lordship, it was never circulated. This paper were merely formulated and kept in the office. Only after this PIL was entertained by this honorable court, the paper came up
Sir,
to us.
it is not for the general public. In fact, they have sent the copies to the superintendent of police, ADM and everyone to, they have informed them and even to the president of that students union also that this bandh is declared as illegal. Despite that, if they have done it, how many FIRs you have registered against any persons?
None, Your Lordship.
Listed, right?
My lord, as nothing happened on that day, my lord, so no one was arrested, my lord. No major
Not
incident
even
took place.
arrested, but at least some complaint should be registered against those persons. Once you have declared it as illegal,
My lord.
and if they resorted to it, you should have taken action against them.
My lord, as per the affidavit filed by the Deputy Commissioner, Superintendent of Police, my lord,
Yeah,
ample of manpower were engaged on that day, my lord.
yeah.
So nothing, ample of manpower was engaged, my lord. So nothing major incident took place. Maybe some small tire burn might have happened, my lord. And no one lost complaint. Any damage, nothing major things happened, my lord.
Now in future, you should take care
My lord,
in advance.
my lord.
So the people should not arrest, the innocent people
Absolutely.
should not be arrested.
My lord, the district administration, my lord, they tried their best to, my lord, convince this bond caller, my lord.
No, do some more,
My lord.
do some more efforts.
Your Lordship, if Your Lordship may allow, just I'll take 15 seconds to make one humble submission.
So you can take 2 minutes, 10 minutes, whatever they go.
My lord, beside that, my lord, since my lord, we have a rules, my lord, High Court rules for filing a public interest litigation. High Court rules 2011. My lord, they said to totally, my lord, give away, my lord. They have not complied with that also. That is also there. That will look.
Ultimately,
Sometimes, my
sir,
lord, yes, technically, my lord,
you
yes.
don't want to go into all these technicalities. Ultimately, if they have raised some issue, you have to address those issues.
My lord, yes. But when there is a rules, it has to follow, my lord.
Your Lordship, I humbly believe when bun call like this instant one, which is concerned with petition, takes place in the Republic of India, Your Lordship, I believe at the first place, we do not need to have any violence. The mere calling of the bun call pains our heart, Your Lordship, from morning to day.
Nobody is denying to that.
So at least,
Yes, peaceful protest is a part of democracy.
yes, Your
But
Lordship.
certainly it should not be violent and the people should not be harassed.
And that day, Your
Then the
Lordship,
people should, but whatever the protest voluntarily, then it's okay. Otherwise, people can't be pressurized. That is the.
so Your Lordship, at least to set some deterring effect for the future course, if at the least, what I will pray humbly on the part of the petitioners is that if Your Lordship may be graciously pleased to at least direct the state actors to prosecute the offenders of that day, Your Lordship.
Will issue.
If that can be done, Your Lordship, we have nothing more to press.
Yes, this PIL petition is filed by the petitioner highlighting that the respondent Jigoyego Students Union and its office bearers has called for a 12-hour bandh on 26/12/2024 in the town of
Likabali.
in the area of Likabali police station. Full stop. It is the petitioner has raised a grievance that the petitioners have raised a grievance that the police has not taken enough measure to control the situation wherein during the bandh call, the local people of the area concerned have been harassed by the organizers of the bandh and the members of the organization who has given a call for 12-hour bandh in the area of Lakibili police station. So the petitioner has prayed for the following reliefs in the writ petition, in this PIL petition. Stop. Response is filed on behalf of the respondent number 2 and 4 to the writ petition, wherein to the PIL petition, wherein it is highlighted that highlighted that the local administration has engaged the representatives of the Yego Students Union prior to a day when the bandh was called for. Full stop. However, during the discussions, initially, the organizers of the bandh calls has promised to call off their proposed bandh. However, in the evening of 25th of December 2024, the student organization took U-turn and declared to continue with the bandh call on 26/12/2024. Countering with this situation, the administration took every steps, including declaring the bandh call as illegal. Full stop. Also highlighted that the police required police personnels and the officers of the administrations were deputed to prevent any untoward incident during the bandh call. Full stop. It is also specifically stated that no major incident took place during the bandh call, and therefore no action against the bandh call, organizers of bandh call was taken. Full stop. The counter affidavit was filed on behalf of the affidavits were filed on behalf of the respondents on respondent number 2 and 4 on 7/4/2025. However, till date, on 8th of April 2025, however, till date, no counter to the same has been filed. Full stop. Taking into consideration the overall facts and circumstances of the case, we are of the view that no further order is required to be passed in this PIL petition. The same is disposed of. However, the respondents are advised to take all preventive measures in future if any such bandh call is given by any organization, including the respondent organization, and take effective steps so the businessmen, shopkeepers, laborers, and should not face any untoward situation during such bandh calls.
Much obliged, Your Lordship.
Yes, next,
But in item 3, on the last occasion, the petitioner's counsel submitted.
He has pleaded no instruction.
Yes, my lord. His brief was taken back and he has issued NOC, ma'am.
And the last occasion, he took some time to find the. And on the next, last relationship, he has taken that he has also been. Okay. This PL petition is filed by the petitioner. Praying for the following reliefs. Full stop. Response to the PL petition is filed on behalf of the respondents. And during the course of hearing, it was informed to the court on 10/9/2024 that in the issue raised in this PL petition, an inquiry was conducted regarding the validity of land possession certificate issued to the various persons. And during that inquiry, it was found that no illegality has committed in issuance of land possession certificate and the no objection certificates in the reserved forest area of Namsai, and everything has been done in accordance with law. Full stop. On that day, learned counsel for the petitioner raised some time to file a counter to the additional affidavit filed on behalf of the state respondents, and time was granted. Full stop. On 3/12/2024, learned counsel for the petitioner has moved an application for withdrawal of the PIL petition, seeking liberty for the petitioner to file fresh proceeding, assailing the inquiry report dated 9/2024, placed on record by the respondents by way of filing an additional affidavit on 3/6/2024. However, the prayer for withdrawal of the writ petition was not granted by this court, and this court, by the order dated 3/12/2024, has observed that the petitioner would be at liberty to bring on record the pleadings in the PIL itself if it has any objection regarding the inquiry report by way of filing an additional affidavit. Full stop. On 3/12/2024, again, time was granted to the learned counsel for the petition to file additional affidavit pursuant to the direction given by this court on 3/12. This is 3/12 again. How two orders are? That's all. On 4/2/2025, learned counsel appearing for the PIL petitioner has informed the court that the brief has been taken back from him and he has also given. However, in the interest of justice, the court has granted 2 weeks time to the petitioner to engage a fresh set of counsel. Full stop. Till date, today, none has appeared on behalf of the petitioner. in such circumstances, we are of the view that in view of the fact that the respondents have already set up an inquiry regarding the alleged illegality in issuance of land certificate, what is this? Land possession certificates and NOCs in the reserve forest under the Namsai Forest Division, and as per the inquiry report, no illegality has been committed in issuance of the said LOCs and NOCs. No counter to the inquiry report is filed on behalf of the petitioner, hence no further order is required to be passed in this petition. This is therefore disposed of.
Objection, ma'am.
Yes. This state is supposed to file an affidavit in this matter.
My lordship, they have been served as extra copies yet, my lordship. Your lords have served already
When?
this morning.
This morning.
Yes, your lordship.
You are in receipt of that?
No,
She's saying
maybe in the office. In office, we have served.
you have submitted that?
Yes, your lordship.
Okay. Learned counsel appearing for the petitioner has submitted that the extra sets have already been filed in the registry. So stop. The counsel for the respondents are supposed to collect the said extra set from the registry and thereafter to file counter to the writ petition within a period of
3 weeks.
within a period of 3 weeks from today. Just after 3 weeks.
Yes, your lordship.
State is required to file a reply.
My lord,
Why this is under challenge?
my lord, we require some more time, my lord.
How much time?
My lord, 3 weeks time, the requisite copy, my lord, that's also required, my lord. That's
What do you mean? You are not
Madam-
in talking terms with him.
my lord,
You are not in talking terms with him. Ask him, he'll supply you the extra copies. For these matters, please don't make a mention in the court.
my lord, that's, my lord, 3 weeks time, my lord, within 3 weeks we'll file, my lord.
Okay, then it consider appearing for the respondents. Raise some more time to file counter to the writ petition. Full stop. Time paid for is granted. When? Just after 4 weeks.
My lord. Leave the bench.
Item number 6. May it please your lordship. May it please your lordship.
Yes.
Lordship, I am for the item number 6. My senior counsel, Mr. D.K. Das, is out of station, lordship.
Senior counsel is?
Out of station, lordship. So I am paying for 3 weeks time, lordship.
Why 3 weeks? In fact, the court has already observed
Yes, lordship, but
on the last occasion.
yes, lordship, but he is be
310/2024 order.
yes, lordship, but he
The court has already expressed its prima facie opinion.
yes, lordship,
That,
but he will be available in the physical mode, lordship.
No
That's why.
court adjudication is there in this PIL petition.
Yes, lordship.
310/2024.
Yes, lordship.
It's almost for more than 6 months.
Maybe, lordship. I only have been instructed.
What do you mean by maybe?
Lordship,
It
I'm
is
not.
there in the order
No,
sheet.
lordship. The only thing is that I am not an engaged counsel in this case, lordship.
Then why you are appealing?
I have been just instructed to take time for 3 weeks, lordship.
Why 3 weeks?
As he will be out of station, he is already out. He will be coming
The
on the
alignment
next week.
sketch map and the second alignment has already been finalized. Now what remain in this matter?
Lordship, my
You have
senior,
prayed for this only.
lordship, BRO is also important. BRO affidavit, lordship. They have not filed yet.
There is no need of that.
Maybe, lordship.
There is no need of that. Once the alignment is already approved, what remains then? BRO has to construct the road as per that alignment, that's all.
Yes, Lordship, just.
No, we are not going to adjourn this matter, sir.
Lordship, just maybe 2 weeks, Lordship, just.
No, not at all, not for a 2 minute even. Where is the senior counsel? Or where is the counsel who is representing the petitioner?
He's in Delhi, Lordship, he's in Delhi for his son's education, some admission, Lordship.
Sir,
regarding-
Mr. Who is that? DK Das is the counsel?
Yes, Lordship.
On 3/10/2024 also, he was not present and Mr. K. Mehna made a mention on behalf of him. On that day, it was said that since the learned counsel for the petitioner having medical emergency, therefore it was listed for 4 weeks.
Yes,
We
Lordship.
can very well address the court on through video. We are
Lordship.
placing it tomorrow. We are not going to adjourn this matter further.
Lord,
This tomorrow.
Lordship, he is out of station. He cannot available tomorrow, Lordship. At least next week.
You are also appearing from the out of station.
No, Lordship.
You are also appearing through video. Where are you situated now?
I mean Guwahati, Lordship. I mean,
Guwahati. If a person is appearing from Guwahati, why can't be appeared through the video conferencing from Delhi? Ask him to appear tomorrow.
tomorrow. Lordship,
Yes.
can it be day after tomorrow?
No, not at all tomorrow. This tomorrow.
Lordship, can it be day after so that I
Tomorrow,
can inform him, Lordship?
him now.
Okay.
Tomorrow.
Okay, Lordship. Oblige.
Yes.
May send, my lord. Lord, I'm praying some more time, my lord.
You are for?
Corresponding number 2, 5, 6, 7, and 8, my lord.
Yes.
I'm on behalf of the petitioner.
Yes. Argue it.
Time may be given. 2
Are
weeks
you-
time.
For what?
Reply.
No. We don't want any, we don't need any reply. Argue it.
Yes.
What's your prayer in the petition?
Lordship,
What is your prayer in the PIL petition?
Lordship, my prayer is for Lordship, there was a misappropriation and embellishment of fund with regards to RGBB scheme. So we pray that this honorable court may give a direction for inquiry.
Why don't you file a criminal complaint? File a criminal complaint. You are raising, you have raised a issue that embezzlement or misappropriation of money is there. File a criminal complaint. It is always there.
Lordship.
File a criminal complaint. Why this PIL petition?
It is, Lordship, actually, I'm appearing on behalf of H only.
Who?
Yes,
Who or he may be, sir.
Lordship.
Today you are appearing, na?
Lordship.
Yes.
Yes, Lordship.
Yes.
Yes, Lordship.
You file a criminal complaint.
Lordship, direction may be given, Lordship. Yes.
But pass an order.
Deeply obliged.
Delay
How much delay is there?
376 days, Lordship.
What is the ground for condoning the delay?
Lordship, there was a consultation among the
Huh?
department, Lordship.
Department?
Lordship. In paragraph, Lordship,
Read
In paragraph, may I read, Lord? Paragraph two.
two, read.
The copy, that a copy of the judgment and order dated so and so was received on so and so by the present appellants, and the same has been gone into in details by the department. After having gone into the judgment for personal court, the authorities got confused as to from which date the suspensions of the writ petition is to be revoked. That is from the date of suspension order or immediately after the judgment and order dated so and so. Accordingly, the appellant sought an opinion of the law department as to date or on which the petition has to be reinstated, and accordingly, the law department opined that revocation has to be done from the date of suspension order. Is
You
the
should have approached the court to clear that confusion.
lawsuit.
There was any doubt or confusion in your mind, you should have approached the court to clarify this.
That is their lawsuit. Then they have the
Can't be
lawsuit,
a reason for.
The opinion of the lawsuit, even Learned Advocate General was sought.
Opinion of the council,
Learned
opinion of
Advocate-
whom?
From the law department, it was sought. Thereafter,
So
lawsuit,
where is the law department? The law department is situated somewhere in Africa or somewhere else, or in Itanagar itself. So it took some time, so law department itself is here only.
that is their lawsuit.
Then-
No, law department is not the party here, lawsuit. In the writ,
You sought opinion of the law department. And you are saying on account of that, some time was consumed.
lawsuit.
So
And thereafter, lawsuit, opinion of the Learned Advocate General was sought. And in that way,
Advocate
lawsuit,
General was paused, so Advocate General can give his opinion on email itself. It is always open.
that is the lawsuit.
Yes, madam.
My lord, I'm appearing for the respondent, your lordship, will be
Respondent, which respondent?
for the sole respondent, your lordship. For the sole respondent, your lordship.
Sole respondent.
Yes.
Yes.
My lord, we'll be needing some time to file our objection to the delay application.
When this application was filed,
Lawsuit,
there also some opportunity was granted to you.
Yes, your lordship, it was taken up on the
19/11/2024, and it's how much time now?
months, your lordship.
5 months now. If 5 months, if you don't have any objection, then what remains? The matter comes upon for consideration of the IA number so and so with a prayer to condone the delay. Seven. Yeah, seven. Seven. Matter comes upon for consideration to IA number so and so. With a prayer to condone the delay of 374.
lawsuit. I'm sorry,
346,
346 lawsuit. 346.
346 with the delay to, with the condone, with the prayer to condone the delay of 346 days in filing the writ appeal number. This is already registered.
Lawsuit, yes, registered.
Already registered.
It has been already registered.
In filing the connected writ appeal number 32/2024. Full stop. The counsel for the sole respondent sought time on 19/11/2024 to file objection to the condonation application. However, no objection has been filed. Having heard the learned counsel for the parties and after going through the contents of the application under Section 5 of the Limitation Act and taking into consideration the controversy involved, we are of the view that the delay of 346 days in filing the writ appeal number 32/2024 is liable to be condoned. Hence, the IA is allowed the delay of so and so days is condoned. List writ appeal number 32/2024 for admission after 3 weeks.
Any deal. Problem.
Another bench.
Item number 9 may not take up, my lord.
Another bench, Mr. Gunaji, another bench, one of which.
Because it's covered.
Yeah, yes.
May I please, madam? Madam, service report to the respondent number 8 is still awaiting.
Who is the respondent number 8?
Madam, this MS Murphy Enterprise, madam.
The construction, the contractor,
Yes,
the contractor.
contractor.
So what is the material you have placed on record which suggests that the width of the road or whatever the material is not in accordance as per the parameters?
Yes, madam.
What is the material you have placed on record?
Madam,
Simply some photographs.
yes, photo.
So
madam.
how on the basis of these photographs we can ascertain that the parameters have not been met?
Therefore, my lord, I have made prayer that inquiry may be conducted.
What inquiry, sir?
Because my lord, this work has not,
Until and unless you place some material on record, we can't order for roving or fishing inquiry. Simply one person will come and say, okay, these parameters are not followed, and therefore you order the inquiry, then it would be very difficult for this court. Each and every construction work, thousands of construction works are being carried out in the states. And if we order inquiry in all matters, how this court will function and how the administration will function, sir?
my lord, even the petitioner has submitted representation.
Which representation?
My lord, may initiate page number 80.
Page number
80.
80.
Yes, madam.
Okay. Now, what is this? What is the material you have placed on record? With reference to the above submitted subject, the petitioners and the concern of the concerned petition like to apprise the following of your kind consideration that the construction of the coming road network has been sanctioned so and so, the construction in process of so and so, that it is dismayed to apprise that the said road is being constructed in a very substandard manner without maintaining any quality work. That if the road is constructed in this way, it cannot be used by the public. So the factions are about to humbling. So what is this? What material ultimately you have placed on record, sir? This simply said that it is dismayed to apprise that the said road is being constructed in a very substandard manner without maintaining any quality work. What material you have placed on record in support of your contention
My
that
lord,
it is simply one line?
my lord,
It's
may
very vague.
kindly peruse the page number 62. Page number.
You are not as if you have approached the court as if you are in a two people are talking in a pawn shop. That this very substandard is going on, and this is what material you have placed, sir?
My lord, may I peruse page number 62.
62.
62.
Yes,
My lord, this is the design of the
no doubt.
walk, my lord.
Yes. So the road is not being constructed as per this design. What is the material before you take cognizance of this fact? You can't file a PIL in this manner, sir. You mean to say that you level a wild allegation and this court is supposed to take cognizance of that and then order that do the inquiry and put the guilty persons in jail and everything. It's your duty to bring material before this court, then only we can take cognizance. In this manner, PI can't be filed, sir. And particularly when a person is approaching the court,
Yes, my lord, because my
the
lord,
court can very well take suo moto cognizance of a fact, but for that also there must be some evidence before the court. Then only it can take. in so casual manner, you have simply placed some record, the design and, this technical sanction order, the tender, and while making allegation that it is substandard, you, do the inquiry.
Yes, my lord, the petitioner has made a representation before the
No,
assistant commissioner.
That's why only, sir, this, read the representation, where is the material in this representation except this line? That it is dismissed to upright that the said road is being constructed in a very substandard manner without maintaining any quality work. What quality work was there? They have not maintained it, they have not followed it. Where is the evidence or any even averment in your complaint?
My lord, kindly see page number 13 of my petition.
Page number
13, 1-3.
1-3.
Yes, ma'am.
Okay, 1-3.
Yes. Paragraph 11, page number 13.
1-3. Yes, read.
My lord, here is a comparison between the actual work and the specification of the workman.
Sir, what is the material in support of that?
My lord, in this support, my lord, I have annexed the representation and the photocopy, my lord.
Photo.
Yes, my lord.
Okay, now it's a, which is this technique? By seeing the photo, we can analyze that, yes, this is very substandard. Which is the technique? You please let us know. So we'll ask the government to use this technique in every construction work. Which is this technique? Is this a new technique or something AI or what?
My lord, this is a physical verification by petitioner, my lord.
Petitioner is an expert? He is an engineer?
Yes,
Or
my lord.
what?
My lord, this petitioner number one.
If he's so expert, engage him and ask him to check all the construction work. He is an expert. He can see the difference by his naked eyes. He's a very expert. You have some divine power or what?
My lord,
Then you are very useful for, even though we'll also ask you to go and the new High Court building is also being constructed. Go and check it.
my lord, even the work carried out by the respondent number 8 can easily identified by
Ultimately, the court has to apply its mind on the material. What is the material? It's substandard order for inquiry and do whatever. Now it's the job of the court because the court has issued the notice. Now the court is to look into it. You have done your duty. This can't be the scope of the PIS. And we are going to impose cost on such persons who are approaching the court without their material. What is the motive behind filing of this petition? You are a rival contractor or what?
no, my lord.
Then,
I am the citizen of the Kain township, so my lord.
oh, citizen of the council, how many PILs you have filed regarding this substandard works date? How many petitions you have filed?
My lord, not so. This is only one.
This is the first attempt.
First.
Then ask your client, okay, even if it is your first attempt, be prepared for the cost. You are not going to entertain these frivolous petitions. Saitam. It's better you withdraw it with liberty to file fresh with better particulars.
My lord, I may be allowed some time to take instruction from the
Take instruction. When?
after weeks.
Where is he living?
He is living in Kain.
Hi.
Kain town.
How far it is from here?
About 400 kilometers.
400 kilometers. There is phone connection.
My lord, there is phone connection, but sometimes phone connection is
What do you mean by sometimes? Take instruction on phone tomorrow.
my lord, maybe not possible tomorrow, my lord. Because
Tomorrow or otherwise we'll pass now an order. They are simply granting you an opportunity. Otherwise, we are going to dismiss the cost. We are not going to entertain such type of things. Tomorrow. Legal and concept of the petitioner prays. A day's time to complete his instructions. This tomorrow. 11. Yes,
My lord,
therefore,
I'm for the, my lord, the appellant, my lord.
appellant.
You know the video.
Therefore, yeah, what do you want to say?
80 days delay, my lord.
This is delay of 3 days. Filing is
30 days,
80 even,
80.
80.
Okay, now
one notification.
notification.
Here petition, they have no complied with notification.
Which notification? So. In superstition of advertising, please go down. So how you are being prejudiced by this? If he has not complied with, how you are being prejudiced? You have not been able to read the brief? You have not been able to read the brief?
No, I can.
I can, then how you are prejudiced? It is for in between us and the,
There's a rule.
it is in,
Complied.
in
They have not
between,
complied with
okay, if they have not complied with, it is between the court and the person who has filed the petition. How you are being prejudiced by this? That they have not, this font size is 14 and coincident 12, single line spacing, margin 4 centimeters. How you are being prejudiced by this? This is the only objection?
No,
Then,
my objection is that your lordship, the honorable single for, as your lordship, after terracing only mentioned.
so you applied for change of date of birth after how many years?
Your lordship, at that time I was 26 years, 24 years. of
After
age.
how many years you have applied for this change of date of?
As per the, your lordship, the notification of the government of India,
Yeah.
it has to be before the 5 years. And I have applied same within 2 years.
Within 2 years.
Yes,
So it is less than 5 years.
yes.
So
So my case is to be considered.
it's to be considered.
Yes.
But even though if you have not filed it within 5 years, how they are bound to consider? If you have not filed application within a period of 5 years from the date of before the 5 years period on the date of your superannuation, why they are going to consider it?
You will see, I was admitted in the year 1990. And
Oh,
I have
you
submitted
applied
my-
for, that's why only I'm asking you, you were appointed in the year 1990 and at that time your date of birth was 1964
Yes,
and you served for many years and thereafter you applied for change
no,
of,
your lordship.
change of date of birth just before 2 years of date of superannuation.
No, your lordship.
These are the facts.
No, your lordship.
Then
I have submitted my representation just after 2 years from date of appointment.
just after 2 years.
Yes,
Then
your lordship, there is a,
they have not changed your date of birth.
yes, your lordship.
Then you approach this court when?
In the year 2021.
2021. In 1990, you were appointed, you applied for change of date of birth in 1992.
Yes,
They have not done anything.
yes.
You kept quiet. And in the year 2021, you approached the court.
Your lordship, the fact is that my representation was before in the year 1994. However, the same has never communicated to me. It was only in the year 2018 I have been informed that my representation was before. Thereafter, I have made subsequent application.
Okay. The matter comes upon for consideration of the application number 52/2025. Before the section 5, the limitation acts with a prayer to condone the delay of 80 days in filing the writ appeal number 8/2025. Full stop. No, the net concept of the sole respondent has filed objection to the application under section 5 of the limitation act. However, having heard the learned counsel for the parties and after going through the contents of the application as well as the reply to the application, we are of the opinion that matter require that the delay in filing, delay of 80 days in filing the connected writ appeal number 8/2025 is liable to be condoned. Hence, the IA number 52/2025 is allowed. The delay of 80 days in filing the connected writ appeal number 8/2025 is condoned. Full stop. Learned counsel for the respondent. Writ appeal number 8/2025 कर देना. Learned counsel for the respondent has submitted that the learned single judge has added in directing the respondents to correct in allowing the writ petition and correcting the date of birth of the petitioner from the service record in his service record from 31/8/1964 to 31/8/1966. It is contended that the petitioner has approached the court with a prayer for change of date of birth at the fag end of his service, and such course is not permissible under the law. Full stop. Learned counsel appearing for the sole respondent has supported the impugned judgment passed by the learned single judge. Full stop. Having heard the learned counsel for the parties and after going through the and after carefully scrutinizing the record and after going through the impugned judgment, we are of the view that matter requires consideration. Hence, admit, since the sole respondent is represented through the counsel, no formal notice is required to be issued. List for hearing in due course. In the meantime, the effect and operation of the order dated 29/10/2024 passed in writ petition number 77/2022 by the learned single judge shall remain stayed.
Deep level.
That's all.